Hey, hello everybody. How are we doing? Back in London on our normal show for our normal Wednesday afternoon. Hope everybody's okay and you're having a good time. So, what we're gonna do today? We're gonna talk about insolvency and all things nasty. So yes, it's not anybody's favorite topic in reality, but it is in fact a useful topic for the SQE and for anybody studying for their LLB or related topics, because we've got a few students that are in accounting and in other related disciplines and business that they have to deal with the issue of corporate failure, insolvency, and how that works out in a variety of domains. So, this is what we're going to do today. Of course, this has implications for people in their personal lives as well. So, imagine this: you're buying something online. I've got a question about this actually coming up. You're buying something online and you're not sure whether the shop that you're buying from is legit or might get into some sort of trouble or might end up kind of failing for some reason, and you're worried that you're loading all this stuff in your card and the goods may never arrive. So that is having an appreciation of what happens in case of insolvency or in case of the failure of the counterparty is useful for you guys to be able to anticipate what might happen and to protect yourselves both in a business sense and also in a personal normal consumer sense. So hopefully everybody is up for this. If you guys are enjoying the topic and you want to know more about this, there are some links down in the description that you can follow, and give us a like as you are watching this either live or on the replay. Right, so shall we load our screen with the questions that are coming up? So let's have a look at that. Hopefully the quality of everything is going okay. I've forgotten. I set the computer down to download some stuff. So the computer is still doing this. So if the beginning of this transmission has been a bit iffy, this is my fault for not remembering to switch off stuff that the computer is doing. So let's try and share screen for the slides that we've got for today. Let's see where we're at. Okay, we should be here. Share. And lucky enough, we have finished with the nasty downloads, so we should be up and running. So now what you see, guys, is the slides in the screen, and I have been reduced myself down to thumbnail size at the bottom of the screen. Okay, now, actually, how could I have forgotten about this? Before I'm moving any further, I've got a giveaway for you guys. Yes. So I am clearing up the place, and I have discovered that from the time that I was preparing for the SQE and getting on top of all the information for the exam and getting all the material and understanding what to study and how to study and reviewing all these books and reviewing the materials and reviewing the prep providers and everything else that I've been doing for the last 3 or 4 years to understand what's happening with this gift given to us by the SRA. I collected a large number of books that I am not currently using. So what I'm going to do a series of giveaways for you guys. So we are having a giveaway of SQE books, and actually I have so many of them, I'm going to do multiple batches. So the first batch, the lottery is happening this Sunday. It's going to be the 9th of March, unless I'm mistaken. Hang on a second there. Yes, Sunday, the 9th of March. I'm going to pick a winner. How do you participate and join in for an opportunity to win these books? The first batch, as you can see, are some from OUP, some from the college, and some from the revised SQE. So they're all the kind of key titles to get you going for SQE1. Go to glintis.co. I cannot even say my own website. glintis.co.uk/giveaway, and that will give you the information on what you need to do. Effectively, this is open for subscribers to my newsletter, the newsletter being newsletter@glintis.co.uk. This is open both for old, current and new subscribers. The only thing you need to do to participate in the giveaway is to put to send an email to newsletter@glintis.co.uk, and the subject matter of the email should be books. That's it. So old newsletter subscribers need to do this. New people who are emailing this will also be subscribed to the newsletter and get to participate in the giveaway. So then I will pick at random one of these people who send me these emails, but get in there because I've received a lot of emails already. And then I will make a selection on Sunday and email the person who wins with the newsletter on Monday. And then if you missed out on that one, you're going to have to wait for the next batch of books that I'm going to put in another giveaway later on in March. The only thing is, I'm not going to post these things to you. I mean, they're free, but you have to work for it. You have to come to Central London and meet me around Oxford Circus. So you get to meet me in real life. Maybe we can get a coffee as well. And I'm going to give you a big, heavy bag full of these books. So you need to be prepared. A, physically come into Central London. B, see me. C, pick up a heavy bag of books. So, keep that in mind if you're coming with public transport. That's it. More information on this giveaway and what's going on, as I said, on the link that you see on the screen right now. If you feel like some free, they're not the oldest versions, but they're still good. If you're interested in some free SQE books, try and do that one. Okay, guys? So if you like giveaways, give us a thumbs up. So I know if you guys are enjoying this, and then I can do some more. I mean, I'm sitting in an office that is full of books all over the place that I'm trying to get rid of. So, I get rid of them. Good for you. You guys get them. You use them. Good for you. Are we ready for some questions? Going back into the topic of insolvency. Again, horrible aspects of corporate failure for the day. Are we ready? Okay. What are we having today? Today we're having Disneyland. Yes? All right. Scenario 1. Suntech Limited is a solar panel manufacturer, and they've gone into insolvent liquidation. They've got £3 million in assets, but £7 million in outstanding liabilities. The liquidator is now responsible for distributing the remaining assets to creditors in accordance to UK, or English if you want to call it that, insolvency law. Suntech Limited has the following outstanding debts. £1.5 million is owed to a bank, and the bank has a fixed charge over Suntech's factory. £500,000 are owed in unpaid wages to employees. £750,000 are there in unpaid VAT and national insurance contributions that are owed to HMRC. £2 million are owed to unsecured creditors, including suppliers and service providers, and £1,025,000 is owned as loans from shareholders who had previously invested in the business. The liquidator must now distribute the £3 million in assets following the correct statutory order of priority under the Insolvency Act of 1986. Relevant legislation on the topic of insolvency, the Companies Act of 2006, and also the Insolvency Act of 1986. Right, now, question. Which of the following correctly represents the order of priority for distributing Suntech Limited's assets? Are we going with first the secured creditors, those who have fixed charges, then the preferential, for example, the employees, then HMRC, then unsecured? That's it. Is that how we're going? Or are we going unsecured, then secured, then HMRC, then preferential, then shareholders? Or are we going, as in C, HMRC, secured, fixed charges, then unsecured, then preferential, then shareholders? Or are we going, as in D, first the shareholders, then the preferential, then the secured, then the unsecured, and at the bottom HMRC? Or finally, are we going with first the preferential, the employees, then the unsecured, then the secured creditors, then the shareholders, and then HMRC? What do you think would be the correct answer here? The correct answer here, you will be pleased or displeased to know, depending on how you feel you belong in this situation here, would be A. Secured creditors, fixed charge, then preferential, employees, then HMRC, then unsecured creditors, and finally the shareholders. All right, now, why is this? Because under the Insolvency Act, we have a hierarchy of creditors. And when a company goes into insolvent liquidation, the liquidators are going to have to respect this order. They cannot just willy-nilly distribute the remaining assets to whomever they feel like it. So they are going to have to respect this statutory order. So the first is secured creditors, but which type of secured creditors? The ones that have got fixed charges. We have a second question on fixed charges, so I'm going to explain what those are in a moment if you don't know. But for the time being, remember this. If we're talking about secured creditors, the best type of secured creditor is the one that has a fixed charge. So the bank with a fixed charge of a Santex factory is the first to be paid from the proceeds of selling that asset. Then we're going to have preferential, which is the employee's wages and any redundancy pay. And of course, there's a statutory limit on the redundancy pay and all of that stuff, but the employees will go next. After that, we got a secondary level of preferential creditors, and that is HMRC. Now, this might sound weird to you guys if you were looking at that stuff like ages ago, because HMRC used to be towards the top of the list, and then it got dropped down together with the unsecured. But in 2020, because the government actually needed the money, they brought them up again, and now they class as a second category of preferential. So after we paid the number one secured creditors with the fixed charges, then we paid the preferential, meaning the employees and the pension funds and the redundancy payments and so on, then we're paying HMRC. So things that have to do like VAT, national insurance contributions and all of that stuff, it really comes at that high level. After that, you get the unsecured creditors. Who is that? Everybody else. All the trade creditors, so suppliers, landlords, service providers, anybody who's owed money generally but doesn't have any specific claim over any specific asset ranks at the bottom there. Oh, I hear meowing. We got Cookie. You guys want to see Cookie? Cookie, hello. Come on, Cookie. Should Cookie rank with HMRC or should she rank with the unsecured creditors? Come on, Cookie. Yeah. Okay. Let me get Cookie for you guys. Hello. Yay! There's Cookie. Did you guys miss Cookie? Now, if you would like to support me and Cookie, you have the opportunity to send us a super chat when you're watching these lives. Yes. So for a super chat, you can buy me a coffee or you can buy Cookie some Whiskas. Yes. Would Cookie like some Whiskas? I think Cookie would like some Whiskas. So get there, hit that like button, and then hit the super chat, which is the thing with the little dollar sign in the middle, and send us some money so we can buy some food for Cookie. Yes? Right, sorry about this. So we got the unsecured creditors, which are kind of normal customers and supply creditors. And then at the end of it all, we've got the shareholders, right? And the shareholders don't get anything because clearly if these guys have got 7 million in outstanding liabilities and they've only got 3 million in assets, then there's not going to be anything left for the shareholders. Should we feel sorry for the shareholders? Let me know in the chat or in the comments. Are you bleeding hearts and you feeling sorry for the shareholders? You shouldn't. Why not? You know why not? Because the shareholders are getting a great deal. Because the shareholders stand to lose their investment. So they stand to lose the money that they paid in order to purchase the shares. But they've got unlimited participation on the upside. This is the whole point of separate personality and limited liability and capitalism as we know it. So you pay the money to purchase the shares. If the company does great, you can benefit, and there's no ceiling to the amount at which you can benefit. But if it goes bust, the worst thing that can happen to you is you lose the money that you paid for those shares. That's the bottom end of your obligation. So the shareholders rank at the bottom, and that is perfectly correct and expected, and it makes the whole system work. Now, you will notice, however, that there were some loans from the shareholders as well, right? This is in addition to the money that they paid to purchase the shares. For those loans, unless they obtain security, they will class as unsecured. So it is possible that somebody who's in a shareholder has got also other relations with the company. That's fine. But if we're talking about shareholders just in their capacity as shareholders, they rank at the bottom after absolutely everybody else, which means, do the shareholders ever get anything back? Nah, they don't get anything back because the company is going bust because it ran out of money. In other types of liquidation, because we're talking here about insolvent liquidation, so what happens when the company actually goes bust, there are other types of winding up, as we call it, when the company is getting shut down. It could be that the company that still has got money decides to shut down, in which case there will be some money to return back to the shareholders, but not for the normal stuff. Okay, how are we feeling so far? We don't have a lot of people watching live today. Maybe the constant ads that YouTube is throwing at you guys is putting you off. I don't know. Is it? If you feel that the ads are bothering you, unless of course you're on premium, in which case you wouldn't see ads. But if you're watching on the free version of YouTube and the ads are beginning to bug you, and that's the reason why you're dropping off, let me know, because I do have some level of control over the ads, so maybe I can stop them. Maybe you guys can start sending me super chats, so I don't have to rely on the ads anymore. Okay. Oh, by the way, yes. I mentioned the newsletter at the beginning. Don't forget to sign on to the newsletter, both to participate in the books giveaway and, to participate in the free MCQs, tips, and discount codes that I send every week. And in addition, if you guys want to become channel members, I wanted to remind everybody that there is an opportunity to become a paying channel member. So for the price of a coffee per month, you get to support me and Cookie, who's currently under the table. And then you get priority access on all the videos. You got a special Facebook group where we hang out together, and then you can do more stuff, and you get kind of advance notice of all the nice things that are going on. That is if you become a channel member. Of course, if you don't want to, no problem. You can continue to watch all of that stuff and participate with me live here every Wednesday at noon from a variety of different locations, even without the house, in London or in other places. Nobody knows where I'm going to be from one week to the next. Okay, so are we ready for the next scenario? We solved this one. We found what was the correct order for a recovery in insolvency, and this correct order was in option A. So let's move along. Right. I'm clicking it and it doesn't go. There we go. Scenario 2. Oof, scenario 2, ladies and gentlemen. Isn't that nice? Yes. Okay. I hope you're enjoying this, even though I have to admit this is a relatively grim subject. Nobody wants to talk about insolvency and corporate failure and so on. So with my company, I'm still there. I wouldn't want to experience the effects of insolvency on a personal level. I'm telling you that. Okay, now let's go. Question 2. Greenbuild Limited is a construction company, and they've taken out a £5 million loan from Citibank Limited. Yes. To secure the loan, Citibank has taken a fixed charge over Greenbuild Limited's headquarters and construction equipment, and a floating charge over Greenbuild's raw materials, work in progress, and accounts receivable. A year later, Greenbuild Limited experiences some financial difficulties and enters insolvent liquidation. The liquidator is now responsible for distributing the company's assets amongst its creditors, and these include Citibank Limited. Question: which of the following correctly explains the difference between fixed and floating charges in insolvency? Is it A, a fixed charge attaches to specific identifiable assets and gives the lender priority over those assets, whereas a floating charge applies to changing assets and only crystallizes upon insolvency or default? Is it B, floating charges rank higher than fixed charges in insolvency, meaning Citibank Limited will recover funds from liquidated stock before selling Greenbuild Limited's headquarters? Is it C, fixed and floating charges are the same in legal effect, but fixed charges apply only to real estate, while floating charges only apply to company stock? Okay. Is it D, a fixed charge allows the borrower to continue using the secured assets freely, while a floating charge prevents the borrower from disposing the assets without lender approval? Or is it E, Floating charges provide greater security than fixed charges as they give the lender control over all company assets in liquidation. Aha. I don't know. What do you think? What do you think, Cookie? Cookie is still under the table looking for an opportunity to jump at me, but I'm not going to let her. Yes. There you go. All right. Let's think about this. Which one best explains the difference between fixed and floating charges? The correct answer is A. A fixed charge attaches to specific identifiable assets and gives the lender priority over those assets, whereas a floating charge applies to changing assets and only crystallizes upon insolvency or default. All right, now, both of these are registrable charges, meaning you cannot tell yourself that you got one and run with it. You need to register it on the company's books on Companies House, and this will be publicly available information. So you can follow the registration information that you find in the Companies Act. I've got Cookie sneezing down here. What happened to you, Cookie? Okay. All right. So the Companies Act specifies what one needs to do in order to register those charges. But the charges are a claim over company assets if the company gets in trouble. Therefore, this needs to be publicly available information. So if you go into a Companies House and you look up a specific company and then you bring up the detailed documentation, you're going to see if there are any charges registered against their assets. And that's very important in you making up your mind as to whether a place is a safe place to do business with or not. Or if you want some security for a loan that you're making, if there are already a bunch of people who already have taken security over those assets, you need to think about this because that puts you on a lower level of priority in collection and insolvency. So one of the things that we discovered already as a difference between fixed and floating charges is that fixed charges rank higher. When we were going through our list previously that put secured creditors, those holding fixed charges at the top, that is important. So the fixed charge will be at the top. Then you're going to get the various layers of preferential, and then you're going to get the floating charges. Now, why is that? Because the fixed charge is actually quite an imposition on the company. If a lender wants to take security in the form of a fixed charge, they're going to say, in the event of insolvency, I'm coming and picking up this item, this exact phone, this specific phone here. And it means that while I'm running the company, I cannot actually dispose of this asset. I cannot change this phone with another one because I've got a fixed charge over the phone. So if I want to do anything in relation to this asset, I need to get the permission of the charge holder. So this is quite limited and quite specific. That's why normally you don't take fixed charges over movable, disposable items. You will take a fixed charge over capital assets, over a building, over machinery, over stuff like that are difficult to move, difficult to dispose of, and quite expensive. But the process itself is problematic, burdensome, and expensive. So nobody goes and places fixed charges for small amounts. They will do this for major loans. That's why primarily you have the banks that are the holders of the fixed charges. Now, a floating charge is more flexible because a floating charge identifies an asset class. So it might say we have a floating charge over IT equipment owned by this company, right? This is an example of IT equipment, which means that in the event of insolvency, if they've got, say, £100,000 in a floating charge over IT equipment, they can come in and collect whatever they find that matches the definition of IT equipment up to the level of £100,000 in value, and then they walk away. But while I'm running the business and the floating charge has not become specific, it has not crystallized, then I can actually change those assets. Because unlike the fixed charge, the charge is not over this particular phone. It's about, IT equipment in general, or electrical equipment, or whatever you want to call it, yeah? So that's why floating charge is better for the business. It is least restrictive. Yes, it gives an amount of security, so it elevates somebody in the order of insolvency. They're no longer unsecured creditors. They've got something to base their loan against, right? They've got some expectation of recovery that is better than everybody else, but they're not as good as the fixed ones because they've got this flexibility embedded. When does the floating charge actually become something specific? At what is defined as the crystallization event. This means that when something that is predetermined in the paperwork happens, then the asset, then the charge over the asset transforms from floating to fixed, and then they can actually come and collect the specific asset. The crystallization event will normally be the application to enter the company into administration, right? Or it could be if we've got tradable elements. It could be a suspension of trading in the stock market. I mean, it could be anything really that's determined in the paperwork, but normally is the appointment of administrators. It means that one of the creditors have been unpaid at a level that gives them the right to trigger the process, meaning that they're owed more than £750 and the business says we don't have the money to pay you. So then they can go to the court and ask for the appointment of an administrator. Usually this will be determined as the crystallizing effect, at which point the floating charge, puff, falls and becomes something specific. Right. So that is the difference between fixed and floating charges. Fixed give you a better level of security, but they're a lot more restrictive in what the business can or cannot do. Floating are less restrictive, but less certain, less valuable, because they put you at a lower level of priority. And when you have the right to come and pick up stuff will depend on what the crystallizing event and when actually that crystallizing event is triggered. So it might cause issues with timing, when we have multiple charges that are conflicting in terms of who gets what and when, which is the topic of the next question. It has to do specifically with the timing. So you can prioritize against different types of charges that are registered against different types of assets, but are also placed at different points in time if they cover the same assets. So we can move on to the next question and get a little bit of clarity on the timing stuff. Yeah. How are you guys doing so far? Is this okay, or is this becoming too intense? Am I doing too many things here? Because I thought I will increase the visual intensity of this by throwing stuff around, yelling, moving, and then displaying Cookie when Cookie comes around. Cookie is currently licking her bowl of food right in the background there. And we don't have Nuggets today. Nuggets seems to be outside or sleeping somewhere, as is his usual practice, but there we go. Okay. Now, are we ready to have a look at what we're doing with the timing stuff, right? Let's have a look at this. Okay, timing. Eco Steel Limited. This is our scenario number 3. Eco Steel Limited is a manufacturing company and they have taken out multiple loans and they're secured against their assets over time. Now, in January 2022, Eco Steel borrowed £2 million from First Bank Limited, granting them a fixed charge over the company's machinery. Come on, Cookie. Cookie has decided now to do her scratch pad. Right, so January 22, Eco Steel borrowed £2 million from First Bank Limited, granting them a fixed charge over the company's machinery. In August 22, Eco Steel borrowed £3 million from City Finance Limited, granting them a floating charge over the company's assets, including machinery, inventory, and accounts receivable. She doesn't want to leave that thing alone. In June 2023, Eco Steel Limited borrowed an additional £1 million from Metro Lending Limited, which was secured by a fixed charge over the same machinery that was already subject to First Bank Limited's fixed charge. Eco Steel is now in insolvent liquidation, and the liquidator must determine the order in which the secured creditors will be repaid. Question. Which of the following correctly explains how the priority of these charges will be determined in insolvency? Is it A, First Bank Limited will have first priority over the machinery, followed by Metro Lending Limited, while City Finance floating charge ranks lower than both fixed charges? Is it B, Metro Lending will have first priority over the machinery as their fixed charge was the most recent, followed by First Bank Limited and then City Finance? Is it C, City Finance floating charge will take priority over both fixed charges as it covers all of EcoSteel's assets. Is it D? All three lenders will share. Where is it? I lost it. D. All three lenders will share the proceeds equally as secured creditors have the same priority in insolvency. Or is it E? Metro Lending's fixed charge is invalid as EcoSteel cannot grant two fixed charges over the same asset. Aha. What do we think is the right answer here? Let's have a look. This is scenario 3. The correct answer is again A. First Bank Limited will have first priority over the machinery, followed by Metro Lending Limited, while City Finance Ltd's floating charge ranks lower than both fixed charges. Okay, why is that? Why does that happen? Because under the rules in insolvency law, the priority of secured creditors depends on the type of charge and the date of creation. And in addition, the coverage of the charge, because it could be that they are covering different things. So on the assumption that they cover the same assets, we need to think of the type of charge and when it was created. The general rules, as we've seen, suggest that the fixed charges take priority over floating charges because the fixed charges attached to specific assets, for example, some machinery in there, they will rank ahead of the floating. Here we've got First Bank that in January 22, they put a fixed charge, and then Metro Lending has a later fixed charge. Both of the fixed charges will take priority over the floating charge, right? So this is point number 1. Fixed is better than floating. If we got multiple fixed charges over the same assets, what do we do then? Fixed charges rank in order of creation. If two fixed charges exist over the same asset, priority is determined by the date of creation, unless the later charge was granted with the earlier lender's consent. This does not seem to be the case here. Here, First Bank Limited in January 22 has first priority over the machinery, and then it is followed by Metro Lending. Now you're thinking, what could be the point? Because why would you place fixed charges over the same asset? It's possible that the sale of the asset generates more money than the initial charge, right? Because if the asset sells for a lot of money, it can satisfy the first fixed charge, and then it leaves money to satisfy the second fixed charge. So there is a logic in having multiple fixed charges over the same asset, even though the second one, the more recent one, will rank lower. So it's not, people are not just, they haven't done it by mistake. It's not that they were not paying attention. It could be that the asset is actually genuinely more valuable than the amount of the charge. Now, what happens with the floating charges? The problem with the floating charges is because they come last, they may be subordinated to other preferential creditors. So City Finance here has a floating charge from August 22. This will rank below both the fixed charges that we've seen, but it will also rank below the preferential because floating charges are subordinated to preferential creditors. This will include employee pension funds, HMRC obligations for kind of VAT and all of these costs, right? So we are in a situation, therefore, that the fixed is better than the floating, and the floating actually is no better than the preferential. So having a floating charge is, in the end, a good idea because it doesn't leave you in the position of unsecured creditor, but it is not a fantastic level of protection because you're already certain ranks below everybody else. So that's something to keep in mind. Now, one of the questions that comes up in this domain is whether the charge holder, the original charge holder, can prevent the creation of additional charges. Now, this is a good one because the case law here is a little bit complicated. The creation of a prohibition in the generation of additional charges of the same nature can be put in the documentation, but it only binds third parties if they are aware of the prohibition. So this is where we've got a bit of a problem, right? Because I told you that the documentation on the charges is registered at Companies House and is obvious, but that does not necessarily mean that the whole T's and C's are available. Therefore, we have had situations in the case law where there was a prohibition in the creation of additional charges, but because this was not communicated to the new charge holder, it did not bind them. Now, as we're doing this for the purposes of the SQE, this is getting a little bit complicated and is going a little beyond what you would need to know to answer multiple choice questions for SQE1. However, if you are approaching this in another context of study, then this might be something that you come across in your documentation. So, pay a bit of attention to this. If we're talking about priorities, we're thinking about the type of charge, we're thinking at the time in which the charge was created, but we also need to have a look at the exact terms and conditions, Cookie, the exact terms and conditions that accompany those charges in case they create prohibitions against other charges being created that rank at the same time or in competition to the original one, right? So I do appreciate that this is a complicated area of the law, but that's why I thought it might be a good idea to focus our live stream today on these to get some clarity on the order of priority in insolvency, get some clarity on how the creditors behave, get some clarity on the different types of charges and their sequencing. So that puts you on a path to understand these things better and helps you a little bit in case you come across questions like this in the actual exam. And, this is the sort of thing that does get examined. So we can move on now to the last question that I had for the day that is more generally about consumer protection in the context of insolvency. And we're going to see how we fare for this one. So I've changed the slide so far as I can see because I've got Cookie in the middle. So there's Cookie. Guys, say hi to Cookie. So if you're just joining the live stream, this is Cookie, is our cat helper that is helping us for today. Normally we've got Nuggets, but today we've got Cookie because Nuggets seems to be sleeping someplace. Yes. And Cookie is getting very friendly lately and has the habit of sitting on the laptop. Do we have any cat owners in here? Or if not cat owners, do we have any cat lovers in the room? If you're a cat lover, give us a thumbs up or put a comment down in the comments box under the video to tell us what is the name of your cat. So this is Cookie. What is the name of your cat? And we can exchange. We can do like a little grouping here of cat lovers and also SQE candidates. So SQE candidate cat lovers. How is that for a subgroup? Should we do a Facebook or a Discord group on this? Cat lovers who are taking the SQE. What do you think? I think it sounds like a great idea. Okay, now scenario 4. Sophie is planning to buy a luxury sofa for £3,000 from Elegant Living Limited. This is a high-end furniture retailer. Now, the store has told her that the sofa is going to take 12 weeks to be custom made and then delivered. So Sophie is excited about this, but she's concerned about the possibility of Elegant Living getting into trouble and becoming insolvent before she receives her sofa. She wants to ensure that she does not lose her money if the company goes into liquidation before delivering the product. Of course, the assumption here is that Sophie has paid the £3,000 in advance, right? So she's paid before she has actually received the sofa. So question for you guys. Which of the following steps would best protect Sophie from the risk of losing her money if Elegant Living Limited becomes insolvent before delivering the sofa? Is it A, pay by credit card, as Section 75 of the Consumer Credit Act of 1974 provides protection if the retailer becomes insolvent before delivering the goods? Is it B, pay by cash, as this guarantees that the retailer has received the full payment and must fulfill the order? Is it C, sign a contract that says no refunds, as this ensures the retailer is legally bound to complete the order despite insolvency? Is it D, wait until the store has a sale and buy the sofa at a discounted price, reducing her financial risk if the company fails? Or is it E, transfer the full payment via bank transfer as this proves that she has a valid contract with a retailer and will be the first in line for a refund if the company becomes insolvent. Have you ever found yourselves in this situation that you ordered something expensive online and then it did not arrive because the company got into trouble? I hope not. And I don't know how long you guys have been around. Do you remember the House of Fraser? Yeah. It used to be like a series of department stores. I think they've pretty much all shut down physically now, but they have relaunched online. So this used to be like a big department store. I mean, not great luck for department stores. We also had Debenhams that also went bust, right? Now, what has happened with the House of Fraser is that you used to buy a lot of things from them, including kind of home goods like this. They had couches, they had equipment, they had kind of kitchen things, all sorts of things. So the people could also get gift cards, right? So it was very common if you were buying somebody like a communal gift, like I don't know, do you get for the teachers of your kids at school? Do you get them like a Christmas gift? Well, you put money in a gift card and then give them the gift card. Hopefully, you don't give your partners gift cards because for any men in the audience, this is really bad idea. Yeah, you don't want to give your partner a Westfield gift card for Christmas. It means that you're gonna spend the new year single. Yeah. So, House of Fraser was selling these things, and in addition was selling gift cards. So a lot of people had bought the gift cards. They go into liquidation, and guess what happens then? The goods that had already been processed and had been given to the shipping company, they still went out. So even though the business went bust, because they were in the shipping chain, they had left the company technically, so they did not become part of the assets that are dealt with in liquidation. But things that had not been shipped, all the orders got cancelled, and all the customers ended up being unsecured creditors in the insolvency process. So they needed to look at other ways in which they could retrieve their money. But the people in the worst situation were the people who bought the gift cards, because the gift card is a promise by the company that is going to give the person who presents the gift card that amount in credit to do something. So this is a pure creditor relationship between the store and the person who holds the gift card. Those people were toast. So the people who received the gift cards, because they were not the ones who bought it, right? It got given to them. So even if they were the ones who bought it themselves, they might have some additional tools available. But if they were given the gift card, like the teacher at the school that got the gift card for a Christmas gift, or the colleague who's leaving that after a collection they got a gift card, these people didn't buy it; they received it. They were pure creditors of the store, so they were toast. So they got nothing. Now the question is for the people that did make the purchases, so the customer that had paid but did not yet receive the goods because the goods had not shipped out. Technically, these people would also be unsecured creditors, which is terrible. So what could they do instead? The best option here, the only live option here, is option A. You could get some redress through your credit provider, the people who gave you your credit card. Why is this? Because this is in the law, it's in the statute. Section 75 of the Consumer Credit Act says that purchases above £100 in value, the credit supplier, meaning the bank that gave you the credit card, so we're talking MasterCard or Visa, credit card only, right? If the value of the purchase is above £100, then the credit provider is co-responsible with the supplier of the goods. So if you don't get the goods, then the bank is obligated to refund you as if they were the ones selling you the goods. For credit cards only. None of the other options here work because all the other options are cleanly wrong. Credit card. What would happen to you if you were using a debit card? If you were using a debit card, then you're not protected by the Consumer Credit Act because a debit card is a direct transaction between your bank account and the supplier, and the bank is simply the facilitator. The bank is not providing credit in a debit card transaction. You need to have the balance to be able to get the goods. So the Consumer Credit Act does not apply. But you guys might be in luck because They have changed the law, and now there is an opportunity for chargebacks on debit cards if the goods or the services do not arrive in the way that they're expected. Why is this? Because the bank does not release the money automatically. So when you're making a transaction on your debit card, the supplier will make a claim for that money. The bank will show you that they took the money, so it's been retrieved from your account, but they don't give it right away to the supplier. They're holding it for a certain period of time. That is determined by the type of transaction. If it's for flight tickets, they might be holding on the money for a year, right? It depends. If you bought flight tickets that are, in the future, they might be holding the money for a very long time. So as the bank is holding this money in an escrow account, then they have the opportunity, if you tell them that you didn't receive the goods or the service, to do a chargeback and return them into your account. They have recently changed legislation in the UK to make these chargebacks easier because a lot of people are getting scammed by online providers, so they're improving the protection from this. So if you had used a debit card, you might be able to get your money back through a chargeback if there is a sort of limited period of time between the time that you made the order and paid the money and the time at which the provider goes into insolvency. You're safer with the Consumer Credit Act because then time is not an issue. So long as the goods are pending, then you still benefit from that protection. In addition, you might have contractual mechanisms to protect you. You could be benefiting from some type of insurance, or there might be a contractual promise from a third-party facilitator. For example, PayPal. If you use PayPal to pay for the goods, PayPal is giving you a contractual promise that if you don't receive the goods, then you can raise a claim and they will return the money back for you. Because the PayPal does the same thing as the bank with the chargebacks. They don't release the money to the supplier straight away. They hold on to them to make sure that the transaction is okay first. So if you tell them within the 90 days that they give you as a period to make a claim, if you tell them that you didn't receive the goods, then they will take it against the provider. And most of the time, the provider is scammy or has gone out of business. They will not respond because they don't receive a response from the provider. They will return you back your money. PayPal. So that is not by law. This is contractual, and you choose to deal with PayPal. That's why I'm telling people, get yourselves a credit card and make sure that you use the credit card for all transactions. It has no cost to you. Most credit cards are free anyway. They don't have an annual fee. And if you clear the balance at the end of every month, you don't pay charges anyway, right? So a credit card is a great idea and you benefit from that protection from the law. If you don't want a credit card and you're using a debit card, be mindful of the opportunity for chargebacks. That's some level of protection. But even better, use PayPal or another provider that offers you a contractual promise, a contractual commitment that they will refund you if you don't get the goods or the services from the provider. So these are the things that you can do at the consumer level at your end that can protect you against the failure of your counterparty, right? And of course, these are tools that are available for consumers in our everyday lives because a consumer is not going to take a charge over the company's books and assets about like a consumer transaction, right? So we do have this gap between what businesses and banks and major creditors can do to protect themselves in case of insolvency and what everyday people for low value transactions can do to position themselves better. The one thing you do not want as a consumer, as a customer, is to be classed as an unsecured creditor because there you're at the end of this very long list of people we have already described. So hopefully you guys, if you knew all this, great. This kind of reinforces your knowledge in the context of a multiple choice question. If you didn't know all this, then you received some top money saving tips from Dr. Yannis here. So now you will know what to do not to be caught out. So especially now that we tend to buy all sorts of things online and most people don't take the time to kind of verify the seller. It looks legit, the website looks okay, so they buy stuff. Be mindful that if you get scammed or if the retailer fails and you don't get your stuff, there might be other ways to protect you. Top priority is not to class as an unsecured creditor in an insolvency event. And best ways to do it, credit card, PayPal, debit card chargebacks, right? Thank you. If I saved you some money, you can give me a super chat to say thanks. So guys, we are almost at the end of this. I don't have a fifth question because I wanted to spend a little bit of time going through this stuff in detail for you. So you got to really appreciate what happens in case of insolvency. For those of you watching on the replay, I hope you enjoyed the show. Let me know in the comments under the video how it went. Follow the links that I've got down in the description for additional information, and I will see you guys next week. Thank you, and see you later.